And that,
the issue with regarding All India Judicial Services on the pattern of IAS and IPS is always alive.
that authority, that's another grave breach of, kindly have a look at, let me complete this story first before going to 312 All India Judicial Service, what it is. That committee headed by Justice Goel approved that concept note. Amicus was appointed and the matter was listed in the concept note in the court. So the whole selection will be done by the Supreme Court, and High Courts will now just pick up. What remains of Chapter 6, it's dead.
But we are not inclined to do anything of that sort.
No, it's pending.
No, not even remotely.
After our resistance, the bench was disbanded. After hearing the matter for 2 days, bench of Chief Justice Kehar, Justice Goel, it was disbanded. We said, please, it's a destruction of the High Court. It's an elimination of Chapter 6. Now, what should be the qualification?
Even if we recommend to the collegium some of the lawyers practicing here, you only suggest the names and leave it to the discretion of the High Court entirely.
But here
we call upon those candidates, go and argue before the Chief Justice and the collegium judges, and only after they find suitable, the names have been recommended even from the lawyers of practicing.
That's good. That's very good, Mulaz. That's how
But
it should. That's how it should be.
We thought that there has to be some opening to the lawyers practicing here from different states.
Mr. Dwivedi, the instance which you are quoting,
yes,
I am quite sure that you must be aware that what were the reactions by some of the High Courts.
I appeared for the High Court, Mulaz, for 3 High Courts.
And I wish if a day comes when you display the online discussion, when the opinion of the High Court was sought, how some of the judges of the High Courts reacted, including me.
Yes.
So if there is an issue, there is a point, if there is a need to take a stand, we do take a stand.
That's right.
And I wish if that is displayed. And what I said.
It should be displayed. But therefore, I'm saying, Lord, today we are fixing the age of retirement, we are fixing the quota, we are fixing the criteria, we are fixing, Lord, what should be the quota of the various sources, what should be the age at which there will be eligibility. Then if you allow that petition also, Lord, concept note petition is still pending. Unfortunately, though it was adjourned, it was tagged with Malik Mazhar and it is still pending. So someday, Lord, somebody may feel, Lord, that it's time now to.
Honorable CJ has already hinted, it's the purpose is not to usurp the power of anyone. That
No, so but ultimately to introduce whether your lordship weightage or quota, that's the two broad suggestions. Your lordship will have to issue a mandamus, Lords. And mandamus for what? To make a legislation. The rule of the High Court is legislation at par with parliaments and state legislatures' law, Lords. It's not a subordinate legislation. In some cases, they refer to it as subordinate. It's not subordinate. So you will have to issue a mandamus.
It will be only, as already hinted, for uniform guidelines, for a kind of an infusement of the strength and for betterment of the
not betterment and enhancing the efficiency. That's the only.
So what will the High Court do? High Court has to follow it.
Suppose even
and High Court can't amend it.
We don't know what we are going to do.
No, I'm dissuading.
If we accept any of the suggestions given by the learned amicus, even if quota is provided, it's not necessarily go by seniority.
No, I'm not on what your lordship will do. I'm trying to dissuade your lordship.
We also don't know what we are going to do. That's what we are saying. But even if we do something of that sort, we will not be taking away the discretion of the High Court in recommending the names.
No, if
names would be recommended by the High Court solely on the basis of their satisfaction. On the basis of their satisfaction with regard to the suitability of a candidate to be elevated.
If the discretion is of the High Court is not to be taken away, leave it to the High Court.
But why are you averse to having some uniform policy throughout the country?
No, uniform.
Why should there be some different policy in the Bombay High Court and something.
Because in
there-
all aspects, with great respects, in all aspects, there cannot be uniformity, and uniformity
There can't be
is the wrong goal to say.
100% uniformity. Aren't there promoted judges in the every High Court? Aren't there direct district judges in the every High Court? Is there any distinction that say Madras High Court, 50% are district judges, direct district judges and 50% are promoted? When there is a uniformity in all that aspect,
So uniformity in this matter, my
and
lord,
you rest assured, we do not even indirectly, remotely intend to take away the discretion of the High Court.
my lord, uniformity in this respect, my lord, will be disastrous.
Mr. Dwivedi, you also please keep in, you will,
Yes.
we are quite sure you are aware, some of the judgments have been cited. This court has already intermittently and in one or the 2, 3, 4, 5, 7 high courts, on the criteria or formulation of seniority has already interfered, leaving no scope for the high courts, leaving no scope for the discretion of the high courts. The full court decisions of the high court have been set aside here. And if a particular way of directions have been issued, in some of the cases, even ignoring the statutory rules, what to do? Are we not required to, in sitting in larger benches,
So
to
if-
rectify our own
my lord,
mistakes?
once the High Court makes a rule, if your lordship and matter comes before lordships in a appeal, my lord, the lordship certainly can issue directions. But today, my lord, here is an IA moved by an amicus seeking a direction to protect the promotees.
That's only everybody is giving their viewpoint. It's not that necessarily that we will follow that. view.
But this methodology, my lord, I'm with great respect. my lord,
Evaluation of the best of the possibilities that what can be.
Well, it's my humble submission, my lord, the lordships.
All right,
We record that
Because it's,
we've taken note of the submission,
Yes,
that
yes.
we need not do anything. All right.
Yes.
Now you proceed whatever you wish to say on the submission.
On the submissions made on the other side, including Ms. Vakeja, that there has to be a separate court of our LCD for elevation.
the lordship will take note, do whatever a lordship feels, my lord. I'm trying to I said,
No, we have recorded your submission. We have recorded your submission, as Justice
Yeah.
Raj has rightly pointed out. We should adopt the practice of hands-off.
A, hands off, and B, my lords, even if the lordship has to issue some guidelines or directions, it should be general, so that high court's
How
discretion.
many times have we been telling you that we don't even remotely intend to take away
Yes.
any discretion vested in the High Court?
That's my humble
That's
submission.
all right. It's only going to be a general direction. There is nothing like that intersectionality. We have already indicated to the other side also. There is no question of entertaining intersectionality dispute by us.
Now kindly have, my lords, the second plank, my lord, for dissuasion is the great divergence. So, amicus का note, amicus का note. Oh, नहीं, amicus नहीं. ये amicus. Which page?
23.
Come to paragraph 23. Kindly come to paragraph 23, my lords. Amicus written statement.
Yes.
Paragraph 23.
Yes.
Yes, the chart.
So kindly see, my lord, different states, what is the age gap difference? Andhra, Chhattisgarh, my lord, happens to be on the higher side. Gujarat is somewhere in the middle. Now see Haryana, only 2. This is not something abnormal, my lords. 2 years gap. Kerala is 4, Madhya Pradesh is 2. Next page,
Rajasthan 42 against 13.
yes. Barring the first two, the rests are between 2 to 6. And if your lordship comes to Sikkim and Uttarakhand,
Yes, reverse.
reverse.
Sikkim, what was the strength of judiciary?
Now kindly have a look at paragraph 27. However, the situation is quite different in several other states, where promotee district judges are much more in number than district recruit, direct recruit district judges at the post of principal district and session judge, district judge super time scale, as is evident from the following. In state of Chhattisgarh, as per the seniority gradation list of the cadre of district judges, out of 23 principal district session judge, 14 are promotee district judges. In state of Gujarat, as per seniority gradation list, out of 33, 24 are promotee. So whole list of high courts, which runs through at least 12 high courts, include 13 high courts, including state of West Bengal, which is at K, and Tamil Nadu is H. Delhi High Court is there. So where is the need, my lord, for?
Even for uniformity.
No,
It
there's-
will also be in the interest of the direct
No,
recruits
this
where,
will- this-
where their position is.
No, this will keep on varying. It's not a question that this is a data based on the pre-existing rules. Now with your lordships opening the doors of direct recruit, many of these promotees will get an opportunity to.
If the dynamics change, the law will change. Where 4 of us would not be here.
That's not the point, my lord. To us, your lordships are lordships. My lord. We don't look at the faces.
You also don't, in the latter way.
Your lordship will have to look at the faces.
2010 changes.
For us, your lordships are all judges, my lord. So it
2010
doesn't
changes.
matter, my lord, who is there.
2010 changes, 2002 changes in 2010, depending upon the circumstances existing there.
What?
24, 25, many of the high courts feel that the changes made in 2010 need to be relooked into.
No, therefore let them, therefore I'm saying that such is the variance that therefore there should be no uniform guideline, my lord, directed to the high courts because there is
On
so
the
much of
contrary,
variance. Leave it to
if this variance is removed,
it
will-
cannot.
It will balance the rights of all the stakeholders.
It's because, my lord, there is lot of other factors in play. Let me come to the other factor based on what is happening, my lord.
I'm sorry to interrupt, my friend. Para 25 goes one way, para 27 goes the other way. So there's a whole set of states in para 25 where the district direct recruits are more. Para 27 is what my
Where
friend
the
said.
promoting them.
So there's no uniformity there in
So
any.
that's what we are saying.
Whichever way you correct it, it's very difficult to create.
After 7, 8 years, you are right, the dynamics will change. Now with the 3 years practice at the bar, joining the service, judicial service, as rightly pointed out, part of eligibility for direct recruitment. So after 7, 8 years, the judicial officers will be eligible to compete not only for 25% LDC, but for 25% direct recruitment also. So there can be a possibility that suppose you have a cadre of 100 officers, junior division, out of them, 25 are selected in LDC, 25% are selected in directly, hypothetically, and only 50% are left.
But Lord,
So the
I appreciate.
still completely a new dynamics for
So-
interest seniority
No,
determination.
so,
We are right.
and your lordships have proved the concept of LDC even at that level. So that will further give a fitting to the writer of the, I'm sorry. to it. My apologies.
The impact of it will be only after 7, 8, maybe 10 years that somebody will be able to
We
evaluate.
will not be there. All of you will be there after 7, 8 years and again, take up that issue.
No,
Get it modified.
no, there's something much more than this.
Yes.
Look at the various other factors. Your lordship may have quota if your lordship wants, put weightage, whatever.
We are telling you, we don't know what we are going to decide.
No, I'm saying what,
Therefore, at the threshold, one argument we have obviously we understood. So you tell us what are your oppositions to the submissions made by
I'm
us, so that we can consider. We are not going to decide only on the.
no,
basis
Milord,
of the argument.
I'm not proposing anything, Milord. I'm saying don't do anything.
That's all. Then let the
No,
others
but
argue.
I have to, no, it's not simply by saying ipse dixit, Milord, that I say don't do. Why you should not do it? That's the reasons I'm.
Come to the other factors now.
So now, there are various,
Comparison में क्या करें?
there are
Tells that
there are
for applying the doctrine.
There are
of facts of-
various imponderable factors which operate, my lords, in determining whether there should be a quota, weightage, or not neither of them, or leave it as it is to the high courts. There are various factors. First is, my lord, why is there this age gap, my lords? None of the petitions affidavits are throwing any light as to why, my lord, the judicial officers in the civil divisions, civil judge junior division, are reaching late, my lords. If a lawyer gets an LLB degree at 22 or 23, before your lordship's judgment, there was no bar, my lords, in appearing in the examinations for the junior division. But lawyers were not appearing at 26. The average age of the lawyers appearing in the examination is the most important factor, my lord, which get. In Allahabad High Court, it is 28. Now, please get this data from all the high courts. This is very important. They are all crying about the age gap, increasing age gap. Even Shetty Commission emphasizes. The reason is that lawyers are appearing in this examination at a late stage. Your lordships have not barred the door. It's their choice. I have a choice to carry on with my practice. I have a choice to refuse judgeship. I have a choice to appear, in lords, in the 7 years examination upon reaching 35 years and go straight to high HJS. And I have a choice, my lord, to go at the earliest, at the lowest rung and take the long route. So an individual lawyer is exercising his choice. And if I exercise my choice at the age of 30 and 32, I'm bound to be there, my lord, the age gap will be there. And in the examination experience in the Allahabad High Court is that the average age is 28 years. We have mentioned in our affidavit, if your lordship has that affidavit.
This is volume 3, R1, page 120.
Volume 3, R1. कहाँ हमारा affidavit? Now, if average age is 28, which shows, my lord, that the large number of people are appearing in the examinations beyond the age of 30 years. And none of the promotees are giving your lordships a data, my lord, from different high courts as to at what is the average age. Now, if I choose to appear at the age of 35 and become a munsif, my lord, and then I complain, my lord, that I don't get a fast track. So these are the problems which are existing there, my lord, and these facts are not before your lordships. Whatever solution your lordship will find will be in the absence of material data. Kindly have paragraph 7 of my affidavit. And now your lordships have put a 3 years bar of experience. So they will appear naturally, my lord, at a later stage. That's a further. Earlier there was no bar. Now, in the interest of efficiency of service, my lords have rightly put that bar. So therefore, my lords, it's not a question of a difference of age gap between the two groups and who is reaching and who is more or who is less. You have to keep in mind the whole overall efficiency of the judicial system, my lord. That's the most important thing. And that's why, my lord, this 3 years bar has been put, notwithstanding the consequence being that they will be delayed. However, even if 3 years is taken to 23 to 3, 26 and 26, because before 35, nobody can appear. So they complete 7 years also for directly appearing. So who prevents, my lord,